Hello, Mark Laudy here at IPBC Global 2014 in Amsterdam. One of the most important speakers at the conference this year was the President and Chief Executive of Philips, the electronics giant. As a major sponsor, he obviously not only helped to contribute to the event in terms of value, but also in terms of the information and the insights at the electronics giant. And one of the important points about Philips, of course, is the fact that they are so involved in intellectual property, both in terms of deriving patents as well as licensing them in their open innovation concept. I'm joined by the Chief Intellectual Property Officer at Philips. He's Brian Hinman. He joins us here at the IPBC Global studio. Thanks so much for coming by.
Thank you.
Let's talk briefly about you and your background, and also where Philips, where you see Philips going. You obviously, as the successor to Ruud Peters, who filled those shoes for the last 20 years.
Yes.
Obviously, there's a long track record of IP at Philips, but you'll also want to be putting your own personal stamp on it.
Right.
What do you think you're going to take it?
So I think one of the luxuries that I've had of taking over an organization as successful of a long history of having a great portfolio, the infrastructure, everything works, and it's a solid organization in and out. So I haven't had the necessity to make broad sweeping changes because Ruud had done such a fine job of really finalizing every element of the organization. So I don't anticipate having to do these big sweeping changes. The challenge that we always have in any operating company is making sure that we're aligned with our business, right? So the business strategy has to align with our IP strategy. So I take great efforts in making sure my team is aligned with the executives in each of our product and services organizations and making sure we understand fully their strategy from a product and services perspective, and then we accurately map our IP perspective and mirror that strategy.
But still, as Frans van Houten, your chief executive, said yesterday in the opening session, you joined the company in a very different world than Ruud Peters was in. So what are some of the unique challenges that you think you'll be facing?
So I think, the Philips has gone through a transformation, right? So we've got out of the consumer electronics business, and we've siloed ourselves into three sectors. We've got healthcare, we've got consumer lifestyle, we've got lighting. But even as we move away from that but as we merge into domains, I'll call them domains because these are areas that overlap some of those segments. So if you think of the area of continuous personal health, right, it'll wrap in elements of healthcare, elements of consumer lifestyle, and that'll result in products. So as we embrace the world of digital and we get more into the connected world, then that creates a different look to our portfolio. We have to think ahead of the game and see where's the world headed in the world of big data, in the world of digital, and the Internet of Things. Those are things Frans pointed out yesterday, very important to us, and we're having the challenge to go to the business and really be thought leaders in trying to guide them down this roadmap of figuring out what's the IP landscape for those areas and how best do we protect those products and services as we migrate to those domains.
Do you have some answers to these rhetorical questions already?
Yes, absolutely. We understand, we're getting a better understanding of big data and how it operates. And we're getting a better understanding we have a real good understanding already about the world of connectivity through some of our vestige consumer electronics businesses where we had wireless communications and that type of technology areas. And we are getting a firm understanding of looking at our product roadmap from these areas like connected personal health and big city lighting and horticulture and areas like that. I have some really smart people that understand fundamentally how the technologies work, and we work closely with our R&D functions and with the chief strategy officers of each of the businesses, and we work as a team to try and work together in understanding the product services roadmap, and then they help us as we guide them through the IP roadmap as well.
The Internet of Things, of course, is fridges online.
Exactly.
Irons online, and whatever else there is. So obviously that's associated with huge complexity.
Yeah.
What is, do you think, the big vision behind all of this? What are your insights into why we should even go down that track, and obviously the IP challenges that come with it?
I think it's, you take something like the air fryer. We sell a lot of air fryers. People want to have the ability to communicate, if you will, through an app, and being able to control time, when you want to start it, when you want to stop it, and the same goes through with a lot of the devices you see in the kitchen, in the bathroom, and those are the areas that we are heavily involved in our products, and everything is becoming connected. It's a connected world, and we have to migrate with that, right? We have to be, we've got the products out there. We want to be the first company to innovate and make these things all connected, and so in order to do that, you have to stay a step ahead of your competition from a product services standpoint, but also from an IP perspective. You have to be able to look in your crystal ball and figure out how these devices work fundamentally, and then as you make them connected, what kind of IP does that represent?
What about the opportunity that the connected device, the Internet of Things, provides those that would much rather have your IP for free? In other words, would it not be possible for somebody to log on to your refrigerator, so to speak, and actually find out more about the fridge than you're willing to let on?
Yes.
So how do you deal with that very unique challenge?
Well, that's a very good question. We're tackling this very aggressively. We actually have, Philips has as one of their largest investments in a company called Intertrust. Intertrust is one of the biggest best providers of secure solutions. So privacy and security are very much an issue when you talk about connectivity, because you don't want to have somebody tapping in and getting that proprietary information. You think about healthcare, which is one of our largest segments, and being able to have hospital to home and having the data. You've been talking about very important data that's you want to maintain that privacy and security. So those are areas that we are very important to us, and we're trying to make sure that as we provide these solutions, we provide them in such a way that that's not going to happen. That the consumer can rest assured that his data is going to be protected.
Now, in a sense, Philips is one of the few companies that really gets IP. Your CEO is deeply involved in IP, whereas in other companies you might find the CEO kind of handing over the IP responsibility to others. You yourself report to the Chief Strategy Officer, Jim Andrew, as opposed to the Chief Legal
Correct.
Officer. So if you were able to share some advice for other companies, what would that be?
I think it's, as I mentioned, when I first started at IBM and I climbed the ranks and took over the IP organization, at the time we were reporting to the General Counsel, and we did a re-engineering study because I felt that was not quite the way to treat a business, because it was really a business for IBM. And so we re-engineered and we reported to the Chief Technology Officer. One of the reasons I took this job, quite frankly, here is because Philips treats it as a business. I have my own profit and loss, and it reports up to the business, right? It doesn't report to the Chief Legal Officer. I think it's every decision you make as a company is a business decision, whether or not you're getting into litigation or you're starting an offensive licensing program. Fundamentally, it's a business decision because it has an impact on that business. And so if you're treating it as business decision, then it should be ultimately governed by a business person,
yes.
Right? Because it makes those decisions easier to make. So as a message that I would send to other companies is, I think this is the right structure.
I mentioned open innovation in my introduction, and the fact that you do have, 400 licensees of your LED technology.
Yes.
Does that signal that you are not likely to be as aggressive as some non-practicing entities might be, the so-called trolls, in pursuing that?
I think when you talk about open innovation, that's a perfect example is through our SSL licensing program. I think it's important because it's a consistent program that we are offering the opportunity for companies to come in and be a part of this ecosystem, if you will. And we've offered it to large companies and small companies. The wrong approach that a company can take is by selecting out a segment of that and going after a certain segment. Then it's not really open, right? So we're trying to be as open and transparent as we can. We've got it on a website, we advertise it, we go out and we talk to companies, and we go to lighting trade shows and try and make sure that we're sending the right message, that we're not out to beat up the business. We're trying to create an opportunity for companies to join this ecosystem with us.
Yes.
And it's a truly open environment.
But shouldn't it be a carrot and stick approach? In other words, does it mean that you won't go after those who are just ripping off your technology, your IP?
Well, when you have a licensing program, you want to send a message that you want to make it fair and reasonable for everyone that's out there. So what's not fair and reasonable is if there's companies out there that choose to ignore the message that we're trying to send. Because that's not fair to these small companies and large companies that have chosen to be part of this program. So we'll talk to the companies, whether or not they're large companies or small companies, and try and get them to be a part of the program. Oftentimes it creates some difficult discussions, but the important part of it is it is a very open program.
But do I get the sense then that you are not going to litigate in as aggressive a style as some others might?
I wouldn't say that Philips does not litigate, because we do have litigation, but we do it when it makes sense, right? We do it when in a very strategic fashion. So I have a team of litigators on my team, and we study this. We study this very actively. We know what our competitors are doing. We know where our competitors are selling products, perhaps that make us a little nervous. They're maybe operating in different markets that we're concerned about, that we want to protect our exclusivity. We want to protect our freedom of action. So there's a lot of components to that. So it's a very difficult and challenging question, actually.
Yeah, and I'm hearing that in how you're articulating that,
yes.
Brian. You're obviously treading a very fine line,
yes,
between wanting to come across as positive and please join our licensing
exactly.
program, and it's a very fine line to tread, isn't it?
Yeah, absolutely. But I don't think the message is not that Philips is this big litigious company that's out there to stop everybody in their tracks. It's not the message that we send. I mean, it's an element of our strategy, but it's not what we're trying to. That's not the message we're trying to send.
Yeah. Finally, let's look at the regulatory environment, both here in Europe as well as the United States. A company your size is not just a taker of the regulatory environment, you're also a shaper of it. What have you told Congress? What have you told the Europeans about how reform should be undertaken?
So the key message that we consistently send, both to the U.S. Patent Office, to the EPO, to WIPO, is quality. Quality over quantity. Because I think that's a large extent why the backlog is so bad, why there's so much litigation that's going on there with patents that are what we call bad patents. Because the issue of quality has not really been addressed, and there has to be a mechanism for these patent offices to really hone down and address that issue. Because having good quality patents is essential to the correct way that countries can manage a patent system.
And good quality regulation won't fix that?
Good quality regulation would make it, if it's done in an effective way. The American Invents Act in the US went a long ways to try and do that. Dave Kapos and I are very good friends. He was a former USPTO director. He did an excellent job at doing that. They have a new set of legislation right now that they've been trying to pass, which just got deferred, and I think the reason why is because it wasn't readdressing this issue of quality, but through the emergence of non-practicing entities. And I think there's just a lot of confusion and a lot of misunderstanding on the government officials on trying to understand what the problem is. If you don't understand the problem, yes, you're not going to get the right solution.
This must be very frustrating for you, because I can well imagine that you've done a few trips to Strasbourg and knocked on some doors over there.
Absolutely, yes. It's difficult. And here in Europe, we're headed to this unified patent system.
Yes.
And which I think is an excellent idea. Unfortunately, I think we're still several years away from seeing that materialize. And the reason why is because it's like herding cats. You've got a lot of countries that have to agree fundamentally to the fee structure, to how this thing is really going to roll out. And we're just not there yet. But it's a great thing to happen when it does happen.
Well, in Europe, they're not known to be fast movers on a number of these
exactly.
fronts. But do you think that they at least have it right, even if it is delayed?
I think so. At least, once again, there's different people that want different things of how this thing should really look and feel. But I think, and that's where we've got some folks on my team that go to the EPO meetings, that go to the WIPO meetings, and really have a voice in trying to shape this the right way, such that it's good for us, it's good for Europe, it's good for companies in general.
And in the meantime, is this a nice to have, or is this a must have? In other words, is there an opportunity cost from this delay?
The opportunity cost obviously is the status quo of what we deal with now, which is a system that's difficult to manage, right? It's difficult.
Is it costing you money?
It costs a lot of money.
Can you quantify how much this delay is costing you?
You know, I can't put a dollar amount on it, but I know that, you know, we do a lot of filing in the EPO. We do a lot of direct country filings. We look at where we do business, quite frankly.
But is it millions of euros or tens of millions of euros?
Yeah, I would say definitely. It's, you know, by having a more streamlined system where you have maybe a one-stop shopping or limiting the amount of work you have to do in doing the filing, it cuts down on the cost, it cuts down on really the difficulty to get your message across in all these different countries.
Thank you so much for spending the time with us here today.
Absolutely.
All the best for the future.
It's been my pleasure.
Brian Hinman, who's the Chief Intellectual Property Officer at Philips, here at IPBC Global 2014 in Amsterdam.